Welcome to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. And now your hosts, Tim Kowal and Jeff Lewis.
Let's talk briefly about writ petitions. A common question among appellate attorneys is what type of criteria the appellate courts use when deciding to grant writ relief. Do you have any practice tips for appellate attorneys about writ practice, and what is something that's really going to grab the writ panel's attention?
I do. It turns out, for a variety of reasons, I spent more time in the writ panel in the last 10 years than anybody else. It's generally rotated on the 4th District Division 3 between the justices every quarter or so, but I ended up serving long tours of duty on the writ panel and saw thousands of writ petitions. So philosophically, I view writs sort of through the lens of temporary restraining orders. And by that, I mean, you really need to demonstrate to me that there's an immediate threat of irreparable injury. There's something that's about to happen that can be prevented, that can't be corrected at some later point in time. You need to remember also that writ relief is an extraordinary equitable remedy. It's only available if the remedy at law is inadequate. Generally, the remedy at law is going to be an appeal following a judgment in the trial court. And the fact that you have to go through a trial is not going to be the kind of injury that's going to get you writ relief. Part of that is practical, because 9 times out of 10, if that case goes to trial, it's either going to get settled or we're not going to see an appeal post-trial anyway, so the issue is going to go away. But the point is, you really need to demonstrate to me, this is my personal philosophy, why the Court of Appeal should take the extraordinary step of intervening in the proceedings at this stage of the proceedings. And it's a rare case. You know it when you see it within the first paragraph of a writ petition. Oh, wait a minute. This is a case we really need to take a close look at.
In the first paragraph, really? Is that...
Absolutely. If you can't convince me in the first paragraph that somebody's going to die before 5 o'clock tomorrow afternoon, your writ's probably going to be denied.
Well, that would make for a very brief appellate consultation then.
Indeed. Well, you know what the statistics are, and many petitions are denied on procedural grounds alone, and they should be, in my opinion. This is back to being familiar with the rules of court, and people that are not appellate specialists doing appellate work. If you don't comply with the rules of court and your writ has procedural deficiencies, it could be denied on that ground alone, and of course, the Court of Appeal is not going to tell you why it was denied.
To what extent does the presiding justice have influence over the outcome of writ petitions, such as by the prerogative to choose the writ panels? If there are there some justices who are more prone to granting writ relief than others?
I think the answer is the PJ has no real influence on the process. The composition of the writ panel from time to time is just, it's a rotating obligation that everybody serves on. But it is true that some justices are more inclined to grant writ relief than I might be. For example, I might have a writ that comes across and I say, we don't need to get involved in this case at this time, or there are procedural irregularities and this petition should be denied for either of those grounds. And one of my colleagues might say, yeah, but it's an interesting issue and I'd like to write on
it. There's no California rule of court that has the interesting issue. I'd like to write about it, grounds for relief. Okay.
I haven't seen that in the rules, but it's to some extent, it's a philosophical question. At the end of the day, what's happening with a writ is somebody is cutting to the front of the line and trying to get the court's time and attention over somebody who's been standing in line and waiting for a year or more to have their case heard.
You have just listened to the California Appellate Podcast. a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again